for tuning in again. Tonight we have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories. Thank you for watching the Truth and Justice with Vivian King. We have another exciting, informative, and educational show planned for you tonight. I am graced to have and blessed to have in the studio Mr. Herschel Cashin. He's a local attorney. He's been out of law school and an attorney since 1984. And he wants to help educate us about deferred adjudication, the difference between deferred adjudication and straight probation, also about sealing your record. The technical term is non-disclosure of your record, and the difference between non-disclosure or sealing your record and getting your record expunged. We'll gladly take any calls or questions that you might have and about anything that we talk about tonight. So please feel free to ask us your questions. And it's a real controversial law because in the beginning, deferred adjudication was more powerful or impactful because there weren't computers. People did not have access to your criminal record. So if you applied for a job and you were on deferred adjudication, which is deferring the adjudication of your guilt, you could say you've not been convicted because that is the legal term. It is true, you haven't been convicted. But now that there are computers everywhere and people can do a background check, people don't know the difference between being on deferred adjudication and being on probation. So it's kind of deceiving, and I think that the legislature really needs to catch up with computers and the terminology because the effect, I guess, with jobs is probably about the same. But I'll let Herschel Cashin just jump right in. So Herschel, thank you so much for volunteering to educate the community about deferred adjudication.
Well, first of all, I would like to thank you for having me as your guest, and I enjoy being here, and I'm going to enjoy trying to educate the people about what deferred adjudication is and what regular straight probation is.
Okay.
And these things are very important. Usually your lawyer addresses the deferred adjudication situation versus the probation right before or at some time during the plea bargaining negotiation. It's important that people understand and realize the difference between regular probation and deferred adjudication probation. They're very important because they affect a person in the present, and they affect a person in the future. And it's extremely important for people to understand the difference between deferred and regular probation. Now, there are two types of community supervision. There is the deferred adjudication, and then there is a regular probation. The regular probation is just like it says, regular probation, in which a person is sentenced to a period of probation for either a misdemeanor or felony case, and it could be anywhere from 6 months to 2 years for a misdemeanor probation, or from 2 years to 10 years on a felony probation. And what deferred adjudication is exactly what it says. The judge has enough evidence to find you guilty. However, the judge defers or puts off the finding of guilt. And you will never be found guilty if you successfully complete your probationary period. And what that means is that the judge is going to give you an opportunity to not be found guilty. And that's very important for many defendants because you don't want to have a record in the end. And already to go through a misdemeanor or a felony case is already a lot. But you don't want a conviction to harm you for the rest of your life. And every time you get in trouble, and every time you get arrested and have to post bond and go through the court process, if your case is not dismissed, your plea is going to follow you for the rest of your life. And many clients or defendants, they say, well, this happened 20 years ago.
Right.
Or that was when I was 17 and I'm 40-something now, or 50. Nevertheless, the computers do not forget. And you may forget, and over time your memory may fade a little bit. However, the computers do remember when you are placed on probation or when you have any conviction. And so every conviction that a person has follows them for the rest of their lives. So when you're in the plea bargaining phase of your case, of course it's best to get your case dismissed or not guilty. And when you're a lawyer and you decide what you want to do, you have to determine if the state has a strong case or a weak case. If the case is weak, then you try to opt for a dismissal or opt for a trial. However, if the facts and the evidence is overwhelming against you, you have to do the next best thing, which many times is a deferred adjudication probation. So that if you successfully complete the probationary period, then you can say, I've never been arrested and I've never been found guilty of any offense. And then you get to the point after you successfully complete your probation, the next step is to have your record sealed. And that is extremely important because having a record sealed, you can say that I've never been arrested and never been convicted. However, that information is still available to many people. It's available to individuals. It's available to schools. It's available to apartment complexes. And many times they check your record to see what type of record you have. And oftentimes you have to explain a deferred adjudication, a regular probation, or explain any charge that may be listed. And so it's important to do the early termination of probation because I have seen many situations where a person has completed, let's say if you're on a felony probation and you've been placed on probation for 5 years. I've seen situations where people have been on probation for, let's say, 4.5 years. You have a dirty year analysis, or you fail to pay your fine, fees, or court costs. So let's say you pick up another small minor violation. Then they can file a motion to revoke your probation, or in this case, a motion to adjudicate if you're on deferred, and your probation can be revoked, and you can be sentenced to penitentiary time. It's important to know that on deferred adjudication, the judge has the full range of punishment if he's going to sentence you. For example, if you have a charge like, let's say, a theft case, and the punishment, the maximum punishment for that offense, let's say, is 10 years. If you are placed on probation for 5 years and you've been on it for 4.5 years, the judge, if the judge or if the probation department or the DA's office files a motion to adjudicate you, then the judge can give you up to 10 years, which is the full maximum punishment range. If, however, you're on regular probation, and let's say if you're sentenced to 5 years community supervision, the most that you can get if you are punished, or if it boils down to sentencing, is 5 years. So deferred adjudication has its advantages. That is that you won't have a record if you successfully complete the probationary period. But on the other hand, the judge gets the full range of punishment to sentence you from 5, 10, 15, or even 20 years. So it has its downside if you mess up while you're on probation. So am I just going on?
Oh, no, you're doing good. You're doing good. You're doing good.
Okay.
Keep going on. I'll ask you some questions when you feel like stopping.
I stop? Okay, I don't want to talk too much.
No, this is all about education.
Or I don't want to bore people, but I think it's an issue that is, that that I would like to do more for people when they are on probation. And sometimes you just feel hopeless and you feel like, well, I was charged, I had to plead guilty, and now I'm on probation, I'm stuck on it for 4 years, 2 years, whatever. But the penal code, early termination is governed by Section 42.12 of the Texas Penal Code, which states that after you've completed either after you've completed 1/3 of the original probationary period or
Now, is
2
that the penal
years,
code or the Code of Criminal Procedure?
Code of Criminal Procedure, I'm sorry.
Okay.
Or 1/3 of the community supervision or 2 years, whichever is sooner, you can file for early termination.
So what's the period now?
After you've completed 1/3 of your
1/3.
probationary period or 2 years, whichever is lesser, then you can file for early termination. For example, if you're placed on probation for 2 years, after you have finished 8 months of probation, and if you've completed all of the terms and the conditions like your fine, fees, court costs, your community supervision, usually they order some community service hours. They may order that you go to some sort of anger management, drug treatment plan, or whatever the judge orders you to do that usually is related to your offense. And if you've completed all of those terms and the conditions after you've been on probation for 8 months of a 2-year deferred adjudication or regular probation, you can file for early termination. Or if you're on or 2 years, like if you're on a 10-year probation or a 5-year probation, after you've been on it for 2 years, then you can file a motion for early termination. And it's completely up to the judge's discretion whether or not the judge wants to grant you probation or not. They have all of the district courts, and then they have all of the different misdemeanor courts, and each judge, or most of the judges, require or have different requirements for early termination. Some judges won't consider a early termination for a sex offense or an offense involving a sex offense or children. You cannot get a deferred adjudication for a DWI, felony or misdemeanor. And so once you've completed 1/3 or 2 years, whichever is less, I think it's important that a person file for early termination, as opposed to waiting till your probation is almost finished and then something happens and then you are revoked. So once you're placed on probation, you're not helpless. You can do something. And I think it's extremely, extremely important that you try to file for early termination as soon as you become eligible.
That's a very good point, because a lot of people don't do that. That also requires you to finish all of the conditions of your probation early. So if you have community service that can last the whole probationary period, do it early.
Correct.
You have to finish all of the terms and the programs that the judge has ordered you to attend.
You must do that before the judge will even consider it. I'm doing a probation early termination right now, and the judge wants to see that your restitution is completely paid up. Because until your sheet says your balance is 0, 0, 0, they won't consider it.
Right.
So you must have paid all of your fines and your restitutions, your court costs, and completed all of your community service hours, and a drug treatment program if it's been ordered, or a alcoholic program if it's been ordered, or anger management if it's been ordered. All of those things must be completely through before you are even eligible, before you should even approach the judge with the early termination.
Well, that's a very good point, because a lot of people don't do that. And maybe they don't do it because you have to pay a lawyer again to do it. You don't have to, but
Yes.
It's best to do that.
It is best
because
to do
the lawyers are in the courts every day, and we have more access to the judges and the probation department to find out what the court's policy is. If you call the court as an individual or a defendant yourself, they might not talk to you about it.
That is correct. And the starting point for an early termination is filing a petition for early termination. And you prepare the petition, you file it with the court, and once you file it with the court, then your the file is ordered by the CLO or the
Court liaison
court liaison officer. She will order your file from your probation officer. The probation officer submits the file to the CLO, and then we speak to the judge. Sometimes the judge wants a defendant to appear in court, and sometimes the judge doesn't necessarily have to see that particular defendant. Oftentimes I inform the client that they may have to appear in court, and oftentimes it's good that the judge has an opportunity to see that defendant or the probationer, and she can ask the probationer questions herself or himself, and the judge can see the transformation in a person from the time they were placed on probation to the time that they go into court for the early termination. But the judge won't consider it unless all the conditions have been fulfilled. And I don't want to be repetitive, but the first step is the petition, and then the DA's office oftentimes is served with the petition. And that kind of leads me to the difference between, well, we'll get to expunging and sealing a record later on. I guess I don't want to jump the gun.
Do the DAs, in your experience, ever object to the probation, or do they just let it, the early termination, or do they just usually, in your experience, leave it up to the judge?
They usually leave it up to the judge unless something heinous has happened, or unless the DA particularly remembers a particular case. If a person was injured severely, the DAs may take an interest in the case. But usually, unless it's a heinous offense that involves like serious bodily injury, usually the DAs don't play a role in the early termination. Now, the DAs will play a role in expunging a record. And we'll get to that later when we discuss the difference between expunging a record and having a record sealed through a petition for non-disclosure.
Let me ask you another question about the difference between deferred adjudication and probation. Do you find a lot of clients or the parents of clients come back and ask you, what happened? I mean, we got deferred adjudication, my son got it, or I got deferred adjudication, but now I can't get a job, and I thought it wasn't a conviction. How do you answer that? Because it is tricky, because deferred adjudication is a legal fiction that, like I said, when there was no background checks, it worked. But now that the background check, people, the employer, a prospective employer sees it, and sometimes they use it just as if it's a conviction. So how do you answer that question when your clients ask you that?
Okay, legally, the Code of Criminal Procedure allows you to legally say, if you're placed on deferred, that I've never been arrested and I've never been convicted. However, an employer will ask you a question of whether or not you've been arrested and whether or not you've been convicted, or whether or not you've been placed on deferred adjudication probation, or whether or not you've been placed on regular straight probation. And it is true that it will show up as a deferred adjudication. However, the defendant has to explain to whomever is requesting the fact that they are on a deferred adjudication. It's important that after you successfully complete your probationary period, that's why it is extremely important to file a petition for non-disclosure in order that your record be sealed. That's important because apartments and businesses and schools, they have access to that information. And you want it to show up as a clean slate. So the next step in this whole probationary period is to get your record sealed by filing the petition for non-disclosure. And then it won't show up. And that's what's important, because anybody that has access to the district clerk's information can pull your record. And when that is done, if it's been sealed, a person cannot pull it up. So that is really the final step that you want to go through in your probationary period. And I think that early termination and filing a petition for nondisclosure are very, very important parts of being on deferred adjudication. That's why it's important to get deferred adjudication as opposed to the regular probation. And when you file that petition for nondisclosure, only the DA's office and certain agencies, governmental agencies, will have access to that information. The FBI, the DA's office, certain regulatory agents will have access to that information even after it has been sealed.
So basically, it's sealed from the public,
Correct.
but it's not sealed from the government.
That is correct.
So if you're applying for a job at Macy's, it's sealed from Macy's.
Yes.
But if you're applying to be a teacher, since the teacher is the government, then the government can see it.
I think that even the Houston Independent School District, for example, I don't think would have access to that.
I think they do.
Oh, they do?
Yeah, I've actually had a client come to me, and they had access to it. I wrote them a letter to explain that we had done a non-disclosure on a teacher who was changing from HISD to Lamar or Dickinson, another school district, and we had done a petition for non-disclosure. It was granted. It was there. But yeah, because they have government access. Right. And the reason why they have government access, as you know, is because, you know, the pedophiles, the security risk with kids, and so they actually do go through the NCIC or the FBI to get their background checks. But I wrote a letter explaining that if a parent ever tried to do a background check of the teacher, that they wouldn't be able to see it, but only the governmental entity, and she did have it sealed from the public. And if that would matter to them. And she got the job. Oh, well, that's... So she did get the job. So I was wondering, in your practice, do you ever have to write letters for people? Because I do sometimes.
No, I haven't had to do that. I've had to explain to certain companies and certain schools that the record has been sealed, and I've had to explain to them what deferred adjudication means and what sealing the record also means. So that does happen from time to time.
Okay. All right. Well, then if you want to, you can talk about expunging. Do you think that's next?
Okay. Expunging is, you have expunging versus sealing a record or filing a petition for nondisclosure. In the Code of Criminal Procedure, under expunction, you can get expunctions for almost 3 reasons. One, if your case has been dismissed and no probable cause was found to arrest you. You have been acquitted or have been found not guilty. Under those circumstances, you can petition for expunction. Sometimes I have found that the DA's office will reply to an expunction. They are not as eager to have something expunged as opposed to sealed. Expunction cuts it off almost completely. And the DA's office can oppose it, and they have opposed it. And excuse me, and 5 times out of 10, well, 4 out of 5 times, they will respond to an expunction. And oftentimes, if a case is dismissed for whatever reason, a lawyer may be able to get your case dismissed, there must be a finding of no probable cause to initiate their arrest. And oftentimes the DAs respond with, there was probable cause to stop and arrest somebody, or we have probable cause to believe that a person had committed a crime. And oftentimes they can win on that issue because oftentimes there is a probable cause to stop somebody, to charge them with an assault or murder or whatever. And oftentimes, if you are acquitted in a jury trial, and you may think that you're entitled to have it expunged, they may oppose that because they feel that there was probable cause to bring the action or bring the charges or indict someone. So they will oppose it, and you will get some opposition from the DA's office, as opposed to a petition for nondisclosure, where most of the time it doesn't bother them. And I have not seen a situation, or I have not had a case in which they have vehemently opposed a sealing of a record or a petition for nondisclosure.
Okay. Well, now with an acquittal in the misdemeanor courts, you have to go within, if you do it within 30 days, file for the expunction, you have to go to civil court, and there's no filing fees if you do it within 30 days.
Right.
And then in felony court, if I'm not mistaken, then it can be almost automatic if you fill out the forms. I don't think you have to, the district courts and felony courts can actually do the paperwork to expunge it right when you get acquitted.
Okay.
Actually.
Yes.
And so the law has changed in that regard. And I think the law needs to change even more because of computers. I mean,
Right.
because of computers, there needs to be a way. I had a lawyer that's been on the show talk to me once about, I think her home state was Michigan. And I found out that Ohio and Michigan and quite a few states have a situation now where if you got deferred adjudication, like for shoplifting when you were a young adult, or some certain misdemeanors,
That's why.
after 5 years or 10 years, you can actually get it expunged.
Okay.
Their law allows real convictions for petty crimes to get expunged.
That's why a deferred is extremely important for if you're 17, 18, or 19 years old, as opposed to pleading guilty to a straight probation. That's why it's important, very important, to have get the deferred adjudication,
Right.
so that you can be eligible to have your case sealed or expunged at some later time.
But a lot of young people don't do that because it's easier to get time served and get that conviction.
That's
and
right.
Some prosecutors will offer that, and some lawyers who are kind of, to me, kind of lazy, they don't want to take you through the hassle or explain it to you. Just say, well, you can do time served and pay a fine. Well, you can get out of there for shoplifting doing that, but the problem is it's on your record for the rest of your life. And I get a lot of calls from people 10 years later that say, what can I do?
Right.
Nothing. Well, why did you just take time served? Why did you pay a fine? Well, I didn't think it was that important. But you didn't get counseled by your lawyer as to the long-term consequences. Actually, for the theft conviction, even if it's a misdemeanor, you're not eligible to sit on a jury because it's a crime of moral turpitude.
That's what a crime of moral turpitude, which all the theft cases are involved in, and the credit card cases.
Even if it's theft by check.
Right. Those and prostitution are what we consider crimes of moral turpitude. And an employer usually does not want you. They don't want you working around money. You won't get a job as a cashier at a store, a supermarket, or even as a bank teller, because they feel that you are morally deprived and they don't trust you. So that's why it's important to get a deferred adjudication for any type of theft case or a crime of moral turpitude, so that eventually you can get your case sealed or expunged.
Right.
And that's extremely important.
It is very important. It is very important. And because we talk about educating the community, I want people who are watching to think about what we're saying. And if you think the laws should be strengthened, you know that the people you talk to are the people you're going to be voting for in November. The legislators, the ones that are in Austin who make the laws, the Rodney Ellises, the Sylvester Turners, the Harold Duttons, those are the people that you need to be talking to because they change the law, they strengthen the law.
Also, I think recently with the DA's office, Devin Anderson is running against Kim Ogg for the district attorney's seat. And just a few weeks ago, I was in court and I ran across somebody that I knew, and she was wondering if she should plead to a probation, a deferred adjudication that her lawyer had suggested that she take. And I believe this was her first appearance in court. And I had heard rumors about misdemeanor marijuana cases being dismissed if you complete a drug course or 8 hours of community service. And I told her, I said, I think that she should hold off on pleading guilty to and getting a deferred adjudication for a marijuana case. I told her I think that you should hold off and reset the case and see what happens. And sure enough, between that setting and today, they have changed the policy at the DEA's office to allow for a case to be dismissed if you successfully complete the the drug course of the 8 hours of community service. And if she would have pled guilty, because even if you plead guilty to a deferred, the judge is going to have to say, well, there's still enough evidence to find you guilty.
Right.
However, I'm not going to find you guilty now. I'm going to defer or put off my finding of guilt to a later time. Had she gone before the judge on that particular day and pled guilty and would have gotten her deferred, she would have been kind of upset this week knowing that the case could have been dismissed.
Right.
And then she's going to, be a little upset with her lawyer because she'd be on probation for 6 months to 12 months. And everybody else's case had been dismissed.
Right.
So
right.
meanwhile, she's having to go through the drug, the marijuana course that you have to go through, and you also have to do the community service hours, and you have to do the random year analysis, and you have to follow all these terms and the conditions and jump through the hoops that you have to jump through, and even have, some judges may even order you to have an alcohol monitor.
Right.
Even for a marijuana case. And so she would have been stuck with all these terms and the conditions when everybody else's case is getting
If their lawyer knew.
dismissed.
Right.
So
well, that's good that you were able to intervene and give her some side counseling. I'm sure she appreciates it.
Well, I think she did.
And the program's already started.
Yes, I have not had a marijuana case within the last week in which I've done that. But because it's only like 2 weeks old that the DA's office has started this new policy.
I'm trying to think. I might have a few marijuana cases pending. I need to check that out.
Yeah, you should, because
It's just for first offenders, I'm
first
sure.
offenders, yes,
Right.
first offenders.
You know what's interesting about that is there can be an argument that it should be for anybody. I mean, because it's still just marijuana.
Well, the political climate has changed a lot in the last 10 years. And with the legalization of marijuana in Colorado and in Washington, it's kind of setting a new direction, and people's attitudes are changing toward the use of marijuana and the amounts that you can use. And society has become more liberal to marijuana and smoking marijuana as opposed to the way it used to be. And since Colorado and Washington have kind of opened the door, many states, we believe, are going to be following their direction. And I believe in our lifetime it may become legal here, even in Texas.
I think so too. I've had a lot of people on the show that think, oh, Texas is too conservative. But the reason why I think it'll change is because, first of all, I think a lot of legislators, even conservative ones, have smoked marijuana when they were in college, because they weren't always conservative.
Yes.
Yeah. If they're over 55, they weren't always conservative. If they lived through the Vietnam era
through the 70s.
and through the 70s and they were in college, they weren't always conservative. They were experimental.
Right.
And I believe that the older legislators will be replaced by younger ones in their 30s. And I think as that happens, people's attitude, the law is just going to change with younger people being there.
That is.
And I think if we're blessed enough to live another 30 years, 30, 40 years, I think we'll see that. But I actually think it'll happen fast. Just like the gay rights movement progressed rapidly.
Yes.
I think that the marijuana movement will progress equally as rapidly.
That is so true. That is.
In fact, I think the marijuana laws will change in Texas before the gay rights ones will. Although the gay rights have changed a lot lately, but I don't know if they've changed in Texas.
Well, it's a matter of the attitudes, and Texas is a conservative state for the most part, and a lot of the conservative are the ones that vote, as opposed to younger people who oftentimes don't vote.
Right.
And with those conservative ideals come conservative voting.
Right.
And we have a large Baptist community in Texas, and a lot of those conservative Baptists vote. And that, I think, if there was a major push by some organization in Texas, I think they could change the laws on smoking marijuana. But also, what happens is that, for example, the DA's office may say, we'll dismiss your marijuana conviction if you've gone through this course. However, many times when an officer arrests someone, they stop a vehicle that's driving, and they say the vehicle was swerving, and upon going to the window, I smelled a strong odor of marijuana on or about that person, or I saw the red glassy eyes. And that in and of itself gives the police officer probable cause to search the vehicle. And upon the search of the vehicle, then the officer may find some contraband, a weapon, some additional drugs. And the marijuana just gave them the probable cause to search the vehicle. And so if the DA's office is not to the point where we just are not going to write you a ticket, we could write you a ticket, but they are not going to legalize it because that will take away the probable cause.
Big time. It would change the whole climate of our criminal justice system in Texas. Because it's my belief that 75% of the people in prison were arrested in cars with the smell of marijuana.
Correct.
They gave the officer the probable cause to search the car.
Right.
So if it's legalized, it would greatly reduce our prison population.
That is so
which
true.
would be good. I mean, I think that, and maybe I'm radical, but I think that it's time for us to stop enslaving and imprisoning people for drugs. I just think the time is now. I just think that we can't afford it as a society. I think it costs too much. It costs too much. I think that, and we have a very violent society. It might not be as much violence as before, but the violence that occurs is horrible and awful. And I would like to see the prisons have enough space to put the violent offenders. I really think that morally, especially as I get older, is that the people that should be in prison are the people who are violent.
Right.
And that because they really can't. But if someone is using marijuana or drugs and hurting themselves, now if someone is violent because of drugs, then I think they should be there with the violence issue of it. You know, stealing for drugs, shooting people, robbing people because of drugs, or to get more drugs for drug-related crimes. But for the violent aspect of it is why we should be in prison.
I think it
needs to be totally changed.
The Texas Department of Criminal Justice, and the prison system is a huge, giant machine. And this machine needs bodies in order to keep it running. And the criminal justice and the TDC system is one of the largest organizations in Texas.
Employers
in Texas. And they need bodies to keep it running. And they need bodies to keep this whole thing working. The probation department is another giant machine.
Right.
And they need bodies to keep this machine running because so many people are employed by this giant machine. And the marijuana, which gives them probable cause to search and find a gun.
Or search and find cocaine.
Or cocaine.
Or bricks of cocaine, or whatever the action is.
That keeps the whole machine running.
Right.
And if you take away that probable cause, then it's greatly reduced. And when you think of all of the thousands of people on probation, state probation and deferred adjudication all over this entire state, it's just like humongous. And the process that Houston is going through in making it legal or dismissing your case is a good thing, but it still gives you probable cause to stop and search, and it still keeps this machine running.
Right, and it's nothing that the DA's office or law enforcement could do at this time until the law is changed. They still have to enforce it, but I appreciate the fact that the district attorney's office has chosen a softer way to enforce the law.
That is, I agree with that.
Because if a child or a first offender has marijuana and they have to do 8 hours for their community, and they have to take a drug awareness class,
right,
that's enough. But I think drugs should be treated that way anyway. If we're going to criminalize it, it should be making people do something for the community.
Yeah,
I just don't believe we should just be having people in jail for 5 and 10 years because they had some crack that they were taking. I just don't. And as I get older, like I said, you see how much money is involved in it and how much money it costs as a society. And you know, in our lifetime, taxes have gone up 2,000%. I mean, society, we can't afford it.
Right.
We can't afford it. And the people who we're putting in prison are not huge taxpayers anyway.
Right.
And so it's like the rest of the society is paying to house people either in housing or in housing in the prison. And to
Right.
me, that shouldn't be the answer.
I agree. But in my lifetime, when I was in high school, people were going to prison for long times, for long periods, just for having small amounts of marijuana.
Right.
And,
It was a felony in the 70s.
It was a felony, and many people that were around during those years did serve felony prison time for possessions of small amounts of marijuana.
Wow.
And it was really fearful of being caught with even small amounts of marijuana for fear of going to prison. And of course that has changed, and we are moving toward legalization, but we haven't gotten there yet. I think if there was an organization that would push the issue, that would organize, then I think it could happen. But until then, I think it's a few more years away.
Yeah, and the reality of growing up in Houston versus San Antonio, where I grew up, is different, because even though the black minority population was small, if we got caught with marijuana, a beer, because back in the 70s you could drive with alcohol, but
Right.
and we could drink it. I can't remember when I was in high school if you could drink at 18 or 21.
18 when I was.
I think it was I think it was 18 because of
18.
Vietnam. I think it was still 18. But even if an officer, if you were 16 or 17 and you were driving and an officer saw us, and they would be white officers because we didn't have black cops really. It wasn't a racial issue. They
Right.
saw us with beer, they just throw it away. After
Right.
a football game, they just throw the beer away and tell you to go home. If they caught us with marijuana, they just threw the marijuana away and told you to go home. In San Antonio, growing up, as I look back, law enforcement in the city used the resources wisely. They only arrested kids who were robbers and jackers. Just what I'm talking about, the violent kids.
Right.
They didn't, if you were, a heroin dealer, and heroin killed a lot of people. A lot of people died behind heroin. They would arrest heroin because heroin was still around, being sold in those little balloons. But they didn't deal with LSD a lot. I mean, in my high school, I saw 3 or 4 people OD on LSD.
On LSD.
They didn't do anything to them. They'd be in the cafeteria vomiting and tripping out and on acid.
Yes.
And a lot of them would be white kids though, but white or black, they just didn't do a lot of arrests. They would just send you home or send you to your parents, or they'd go to rehab. And I guess that's what I'm saying. I just wish that society was more like that again. And if an officer saw a joint, throw it away.
Right.
And just tell them to go home and make them buy another bag of weed. I mean, punish them that way instead of taking up, $20,000 and $30,000 of resources.
Right. I think that, like within Harris County, now that the DA's policy has changed a lot in terms of the marijuana, I think eventually they're going to get to the point of writing tickets.
And the law allows that.
Right.
It allows a cite and go. So write a ticket, but you still have to go to real court, to 1201 Franklin.
Right.
But you can cite and release. That's what it's called, a cite and release program.
I think they've
been doing it in Dallas County for years.
They'll be doing more of that in the months to come. They'll be doing that, but because they don't want to burden or bog down the court system.
Right.
But also, they don't want to take away that tool to search your car. And that's what people need to realize, that smoking weed is not to be done in your car. Drinking is not to be done in your car. And just as sure as the police officer in his report or in her report is going to say, I stopped the vehicle for no lights on, failing to use a turn indicator, the blinker was out or the brake light was out. I stopped them, and then I approached the car, and then I smelled the strong odor of alcohol. The strong odor of alcohol, the strong odor of marijuana on about your person, and the glassy, bloodshot eyes always gives the officer probable cause to stop the car. And if you do not have the strong odor of marijuana on about your person, if you don't have the strong odor of alcohol around your breath, and if you're not looking all disheveled and like you just came out of the bar, then there is no probable cause to stop you, or I'm sorry, no probable cause to continue the search.
Right.
Because we as defense lawyers, one of the first things that we raise or we evaluate a case on is in terms of a motion to suppress, whether or not there was probable cause to go forward with the with the search
Right.
and the subsequent seizure. And so that's, I believe, is why we are not going to legalize the marijuana. But if people realize that that should not be done in your car anyway,
Right.
then you will take away the probable cause to search.
Right.
And that
Sometimes I think that there might not be marijuana in the car, but people might smell like it because they've used it recently.
Right.
And I've even had experiences where I think the client smells like cigarettes, because some
Correct.
cigarettes can be really strong, if they smoke a lot, if
or
they're heavy smokers.
cigarette in
Or
combination with a cigar.
in a cigar.
And
It'll
then-
have a foul odor, foul enough to seem like it's an
Correct.
old marijuana scent.
That is
So I think that happens too. But I do think we need to take that probable cause away.
right.
I think traffic tickets need to be traffic tickets unless
Right.
you're looking for someone. And I just think we just need to be less of a police state. Like I said, I just don't think we can afford it.
Yeah, I believe.
If police officers were doing
Yes.
policing, like watching for the community, looking out, but not arresting people and getting off the street and taking motorists off the street. Now, if they're driving erratically or something and they're endangering people, again, with violence, that's one thing. But just think of happenstance when we have 50, I said 75%, so let me narrow it to 50%, in jail because they just happen to be stopped. I mean, that's not the type of people you want to incarcerate because they happen to be stopped.
Be at the wrong place.
Yeah, just happen to be stopped for a traffic ticket,
Right.
and you fit a profile of where I want to search your car and I can back into the probable cause of marijuana. That should not be the type of people who are filling our prisons. But in
That's
fact,
correct.
if we reported those statistics, it would be alarming. I had the police chief on here, and he agreed with me that it was more than 50%. It might be 75% because they just happen to be stopped. I mean, is that the type of person you really want to put in prison when they're not harming anyone?
Right.
They've run a red light or a stop sign, no accident.
Right.
But you're going to put them in prison for that?
That is, I agree with that.
That's why I don't agree with it.
I agree with you 100%. But that's what I don't think the state is ready to do.
Right.
To take away that probable
Oh, no, I'm
cause.
radical.
Because like I said, the TDC machinery has to keep moving. And I'm not saying I do everything I can against it. But the courts have to keep putting people in jail in order to keep feeding this giant machine. And as long as it exists, it's going to happen.
Right.
But it will be scaled back quite a bit. And once it's scaled back, then you won't see it filled with so many black and brown people. And what's alarming is when I go to court and it appears as though just blacks and browns are the ones committing the crimes. And I've been in the courtrooms on many, many occasions where 85% of the people are brown skinned and black. And I don't think that's, I say, is it just because we're the only ones committing crimes? No, it's not. It's just, but when you do go through the courts in the mornings, the felony courts as well as the misdemeanor courts, it's very disproportionate to our population.
It is, and that's what's so alarming is that to me, it's just easier to arrest someone that doesn't look like you. We do have a phone call. Caller, thank you for calling Truth and Justice with Vivian King. Please turn your volume down and state your question or comment.
Hello, Ms. King and your guest.
Hey, how are you?
I'm doing pretty good. The question I want to ask now, when you talk about probable cause, and like when an officer pull you over and he say smell of marijuana, if he pull you over and if he just want to search your car, what if you say he smell marijuana and there's no scent coming out of your car?
Say that again.
Last part.
That last part?
Okay. If the police pull you over and he wants to search your car, can he just say he smells marijuana even though he don't smell it?
Well, that's what our clients tell us.
That's what they do.
That's what our clients
okay.
tell us. Our clients tell us that when if they're black males, they pull them over, they pull them out the car, they put them in handcuffs in the back of the patrol car on the ground, and then they search through the car, and if they find an illegal weapon or if they find cocaine, then later they'll say the car smelled like marijuana. And what's real interesting about that question is that, you asking that question, is that 90% of the time there's no marijuana in the car.
Right.
It'll just be cocaine or pills, illegal pills, or, you know, methamphetamines or some illegal pistol or a gun or something like that. But really now, if you don't have a record, you can carry a concealed weapon as long as there are no drugs there. But the thing that's interesting is that they never have marijuana.
That is.
And that is so crazy. And I don't know how jurors feel about that, because if you're a logical juror and you don't find marijuana, but yet it smelled like it, there should be no probable cause anyway.
Correct.
Because there's they never find any marijuana. So that's why we know that they're lying.
Okay, the reason why I asked the question, because I was riding up and down the highway, and I see a lot of times I see people pulled over, and I see like 2 or 3 police cars, and they run you through the cars, and they got the suspect standing outside the vehicle, and they just run you through the trunk to going out to the car.
Exactly, and they might find it in the back of the car or in the trunk, but you know it wasn't smelling like marijuana in the car, in the cab.
But it's important for you to realize is that they are looking for something.
Right.
They are trying to find something. It's not like...
and if the probable cause existed, why are you having to rummage through somebody's car for 30 minutes?
Because
they'll also write those reports and say they saw it in plain view.
And they're looking for something, and that's why, or my new case, maybe some marijuana was smoked in the car earlier that day, and then the police says, well, I represent this light-skinned black guy, and the police in Fort Bend said that they saw 2 Mexicans, what appeared to be 2 Mexicans, heading toward Victoria. And so they stopped them because they said that they looked like 2 Hispanic people traveling south on 59. And then when they came up to the car, then they see that these are not Hispanics, but are blacks. And then they say, well, we smelled the odor of marijuana, which gave them probable cause to do the search. So it's a catch-22, but my advice is to don't ride dirty.
Don't ride dirty, and don't admit to smoking marijuana earlier, because marijuana is really a crime that you have to have a usable quantity to even arrest. Right. So you can't arrest for a smell.
Or a roach.
Or a roach, or a amount of some seeds.
And also,
or some leaves. I mean, you know, it has to be something you can smoke.
Also,
okay, thank you.
Thank you, Tracy.
Also, I think it's important that we discuss consent to search.
Okay. Do we have another question? Do we have another caller? Okay, they hung up. Okay, so no caller?
What about consenting to search? Do you think a driver of a vehicle should give consent to search the car if they have contraband or if they don't have contraband?
I don't think you should ever give the police consent to search.
Okay, and so should you be scared and say, officer, I know you can't search the car, won't that make the officer mad?
It should. My advice is to always say, no, sir, you cannot search, and you need to call a supervisor to the scene. Do we have another caller? Caller, you're on. Turn your volume down and speak directly into the phone, please.
Yes, you do. Yes, you have another call.
Okay, well, turn your volume down. What's your question?
My question is that if
you haven't turned the volume down on your TV. Can you hit mute? Okay, what's your question, sir?
My question is that if these people didn't put all these black and brown kids in jail, you got these little towns like Shepherd, Livingston, Diboll, all those people would have no work. That's what they got, all these prison farms located where these people have jobs. The people that used to farm cut logs, haul pulpwood, all that stuff. That's not there no more. So all these little representatives in these small towns, that's what they vote. All these different laws and things where they rest us and get these prison farm. And you go to prison farm, 90% of the people is white guys that old and young, white and black ladies that work at these farms. They wouldn't have no other jobs.
Well, we are smart in this society. So since we already have the money designated to county money, state money designated for those prisons, we can use that money more wisely. We can use that money to house the mentally ill. You know, when there used to be mental health wards, because now the prisons are being used as mental health wards.
Correct.
Everybody that we know that has a mental issue, they end up in prison, and usually it's because they just need mental treatment. Half the people in prison have mental health issues. Right. So instead of it being a prison, it can be a mental health ward, and those people can be right. trained to work there. So we can use our resources more effectively. We can also yes. create industries. I mean, the same money that we use to spend $20,000 a person or $30,000 a person in prison, we can create factories where people get paid, and the county and the state is paying $20,000 to $30,000 for people to make products. We can do that. Correct. We can do that. It's our money. We can spend our money however we want to.
And that's why it's important if we take it a step further and try to legalize the marijuana, a lot less people, a lot more people won't be going to jail.
But see, the thing that we have in this society, sir, just like you're calling, I appreciate the question, is that we think there's only one way to spend our resources. And I want you to open your mind and be educated to the fact that our legislators can spend that money however they want. They got a little bit of money. They don't have to raise our taxes then. You know, if we're producing something besides putting people in prison, not only would the money go to pay someone's salary, those same salaries, then we might be coming up with a product also that we can sell to raise more money instead of raising taxes. So there are other ways to accomplish the same goals in Livingston, Polk County. Right. We can be producing something and using those same dollars to do that. Thank you for calling.
Yeah, that's true. That's true. But if you go to South Texas and East Texas, all those places, that's their whole thing.
But we can change that. We can change that.
I did grand jury 5 times, and I know how easy it is for them people want to send them people up there.
Right.
The DA coming out telling you almost what to do.
Right.
You got these people that, I guess they professional grand jurors that they're there all the time.
Right. It's the same people. We've been told to wrap up. Thank you for calling. We've been told to wrap up because it's 7:30. I appreciate you calling. Please watch next Wednesday from 6:30 to 7:30. Apparently, we were having phone problems tonight because we didn't get the calls in until the last 10 minutes. I apologize for that, and please call next Wednesday, okay?
I will call you back. I watch you all the time.
Thank you, sir. Good night. So anyway, thank you for coming on, Herschel. We're getting the wrap-up signal. Maybe you can take about 30 seconds to say goodbye.
Well, this is very important to me that once you're placed on probation, the final 2 steps are the early termination of your probation and the sealing of your record. These things are very important for you and to your family.
And for your employability. Thank you, Herschel, so much for coming by tonight. And please, will you come back again someday?
I will be happy to.
Thank you, and good night. Thank you for watching, and we'll see you next Wednesday. Thank you for tuning in again. Tonight we have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try